in June, the OECD Competition Committee will be holding a virtual roundtable on the subject of the conglomerate effects of mergers. Now, these mergers tend not to be a focus of a great deal of competition authority attention, and in some jurisdictions, they're not even assessed at all. This may be because they tend not to fit within the traditional competition theory of harm framework. They don't involve products that are direct product market competitors, nor do they involve products that are inputs of one another. So where could the competition harm come from? Well, there are really two main concerns. One is a very specific concern associated with coordinated effects. The idea is that if, as a result of a conglomerate merger, you have a higher number of conglomerate firms that have a matching structure that are involved in the same multiple markets, you may have higher incentives to engage in collusion. And indeed, multi-market contact, we know from economic literature, is a key contributor to collusion incentives. The second and much more prominent theory of harm is associated with using bundling and tying that would use market power in one market to foreclose competition in another. So the idea is that a conglomerate merger could enable this kind of strategy. Take, for example, a world where there's a single computer manufacturer that has market power, and it merges with a software producer and engages in bundling or tying so that it can foreclose competition in the software market. Now, assessing whether this really happens, whether firms have the incentive and the ability to engage in this type of foreclosure strategy, can be a little bit challenging. And it's even more challenging to then determine the overall impact on consumers, since we do know that there are many instances where bundling and tying can actually have a very positive impact on consumers. So the analysis is not straightforward. Of course, the Chicago School, which is where we began this discussion at the OECD in 2001, has found in general that firms will not have the incentive to engage in this kind of foreclosure strategy. Since then, there's been a burst of economic research that is focused on some very specific conditions in which harm may in fact arise. And in particular, the potential for harm will really only emerge if you have strong market power in one market and the other market also has imperfect competition, perhaps due to economies of scale, network effects, or very significant barriers to entry. It's also crucial that there is a significant overlap in the consumers for both products. Bundling or tying is not likely to be very effective if it involves forcing consumers to purchase a product that they would not have otherwise considered. Now, some other risks associated with bundling and tying having negative impacts on consumers may arise if there are repeated purchases of one of the product. For example, if it's common to upgrade one of the products, which would increase the incentive to engage in bundling and tying and foreclose competition. Of course, also the feasibility of tying by using technology or compatibility constraints could also be an indicator. And finally, whether there has been proof in the past of the use of bundling and tying strategies, whether they really are a credible strategy. Now, these are just some of the initial indications that we've explored more extensively in the OECD background paper on this subject. Competition authorities in practice, though, face a great many significant challenges in translating these initial indications into something that would meet the evidentiary standard for potential merger harms. Now, these are also laid out in the OECD background paper. Just to name a few, evidence gathering can be very difficult if you don't have a clear direction. It can be difficult to assess where potential conglomerate harms may arise, much more difficult than addressing a typical horizontal merger. There are also the frequent appearance of dynamic competition issues, which can involve grappling with a great deal of uncertainty. And these challenges may actually lead competition authorities to prefer to rely on ex post enforcement actions rather than trying to challenge a conglomerate merger during the merger review process. So all of this suggests that really the assessment of conglomerate merger effects will remain limited. But there are two factors that may cause this to change. The first is digitalization. With digitalization, there's been a significant increase in the use of conglomerate business models. And at the same time, there's been a burst of recent research that has suggested that some of the factors that I just described in terms of increasing the risk and the incentive to engage in foreclosure through bundling and tying, well, they may be more common in digital markets, in particular network effects and significant economies of scale. Second, there are also broader societal concerns about the risk that the increasing size of certain conglomerate firms may be posing for the economy in terms of systemic risk, lobbying capacity, ability to affect public policy. And while these concerns may not be easily addressed within the realm of competition policy, there are some indications that merger review and the assessment of conglomerate theories of harm may, in some cases, be an appropriate use of competition authorities' time and resources. In particular, merger review is a way of preventing problems before they happen, and may be a lower cost way of addressing potential bundling and tying concerns in the future. And second, it should be noted that the concerns associated with conglomerate mergers can be, in many cases, rectified using behavioral remedies rather than structural remedies. This could mean that competition authorities can find an agreement with parties in which parties can still obtain the significant benefits and efficiencies of a conglomerate merger while addressing some of the risks of anti-competitive conduct. And again, this may be a way of minimizing the costs of ex post enforcement investigations. So some very interesting issues and very interesting questions about whether competition authorities can make more use of conglomerate merger theories of harm. To help us along the way, we will have three experts in this discussion. Marc Bourreau, who's a professor of economics at Telecom Paris and who has co-written a paper specifically on digital conglomerate effects. Eliana Garces, who was previously of the European Commission and Brattle Group and is now Director of Economic Policy at Facebook. And finally, James Langenfeld, who is a Senior Managing Director at Ancora and was previously a Director in the Bureau of Economics at the U.S. Federal Trade Commission. So thank you very much for listening. I would encourage you to check out our website, which has the OECD background paper as well as the submissions that we received from delegates on this topic. And stay tuned. Thanks very much.